I mean, honestly, all I eat, sleep, and breathe is this movie. I am so proud of this movie, and this all I've eaten, slept, and breathed. That's a
Yeah,
hard
you
thing
got
to
that.
past
You
tense
got
it
that. Yeah.
for like the past year and a half. So the fact that this movie's coming out on Friday, they don't really turn books like this into movies anymore. And you're not really seeing movie stars be made anymore. I mean, this is her first movie, and like you walk out of this theater and every single person is incredible and firing on all cylinders, and it's just like,
Hi, friends. It's Katie from Without a Crystal Ball. Welcome back to my channel. Well, we broke the story last week about this Van Zandt Inc. lawsuit, the SHAM lawsuit that was filed by Blake Lively's attorneys. And I've now uncovered a second lawsuit where her attorney, who filed the lawsuit in New York County Court, has done this before. And what I've uncovered kind of indicates that her attorney knew what she needed to do ethically in one case, and on the other case with Blake Lively, she did the exact opposite. It's the only case I was able to find of any of the attorneys that had ever filed a lawsuit against only Doe defendants. And it was Samantha Katsy, and it was in 2016 or 2017. And it's a wild one. So we're going to buckle up and talk about that. Before we get into that, a little bit of housekeeping. There are so many rumors swirling around, and lots of people are emailing me, messaging me, sending me screenshots. And listen, y'all, I appreciate it so much. But some of the information right now that's getting circulated is just too much for me. I don't really get into the weeds so much when it comes into like looking at every single conspiracy, but I want to clear something up. ML management is not this like they're not tied to Wayfair, okay? They're not tied to the lawsuit. ML Management, who is the registered agent for Van Zandt Inc., is simply the firm, which is a CPA firm that files business documents on an annual basis, manages taxes and payroll if needed, but not always necessary. And in some cases, they do HR for clients, but it's a boutique business management organization. They're the largest in one of the largest in the country. They have huge clients: Eddie Murphy, Wanda Sykes, Tracy Morgan, Ryan Reynolds, Blake Lively. So many celebrities use this company. Okay. And so we don't need to go digging into their background. We don't need to look at their wives. We don't need to explore who Eric Binder is. Eric is literally just the CPA that registers her business records with the state of New York and California. That's it. Registered agents don't do much of anything with a business. I have a registered agent, and my registered agent is not a part of my business. And so I've heard a lot of people trying to like dig into his life, dig into his wife's lives. I'm not down with that. They're completely irrelevant to the story. They just happen to be the registered agent. Registered agents are the address and the agent that files annual renewals. They file documents with the state if there's updated statements of information, if ownership changes, if you dissolve the company. They also serve as an address for business mail. And so if you need to be served for a lawsuit, they can be the address for the company. So the summons can go to that agent there versus directly to your house. And it also just helps celebrities because their businesses are then not registered at their own home address. And then they don't also have to rent out their own office for their business. Okay. People have noticed that Liz Plank's business, her production company, filed a branch of the company in California in November for Liz Plank Productions, and people are trying to connect her somehow to Blake. All she is using is the same the same management company, ML Management. Okay, that's it. The company Liz Plank Productions was originally formed by who? ML Management in 2017. So it's not as conspiratorial as you would think. So I'm not going to be spending a ton of time going into like the nuances of what we find on ML management and who this Eric guy is because it's not that relevant. But what is relevant here is like looking at the lawyers, looking at the parties in this lawsuit. So looking at each one of the PR agencies, looking at each one of the attorneys, and looking at the firms that are part of this case to figure out, have they done this before? Because Ezra Hudson last week said that filing Doe lawsuits is not an uncommon technique, and it's used to get discovery in cases where unknown defendants are perpetrating something against you. And in this case, she claims that it was what uncovered the scheme by Justin Baldoni because she knew exactly to go to who? Stephanie Jones 4 days after filing the Doe lawsuit. I've also noticed a lot of people on Reddit or again on Instagram or in my messages sending me like, "Oh, I found another Doe lawsuit." Okay. So Doe lawsuits are not uncommon, right? So I think I was watching Ask Two Lawyers over the weekend, and it's not uncommon if you name a defendant. So say it's Blake Lively versus Justin Baldoni, right? And then she could do Blake Lively versus Justin Baldoni and Doe's 1 through 25. Okay. And what that allows her to do is that it means that there could be other people that are not named yet, whose identities are not known yet, that could be added at a time later. It just allows her the ability to modify and amend the complaint if necessary. So using a Doe lawsuit doesn't mean a whole lot if you already have a defendant named. And so if someone is, Wayfair Productions versus Blake Lively and Doe's 1 through 7, you'll see that. One time I got sued and the person thought I had all these trolls working for me. So it was like Doe's 1 through 100. And I was like, I don't have any trolls working for me. But they thought that they would uncover all these people. And they didn't because I don't have trolls working for me. So now that you understand that Doe's are not uncommon when you already name a defendant, what is not common is not naming a defendant and only naming Doe's. Okay. So I wanted to figure out who's done this before. Has this attorney, Samantha Katsy, who works for Blake Lively and filed the Van Zandt lawsuit in New York County Court, has she done this before? Has she filed a lawsuit with a business naming no defendants and sought subpoenas? Has she done this before where she's filed a lawsuit and has not sought judicial notice? And the answer is no. This is the only time she's done this. And it's insane what happened and what I found. So in this county of New York, you can't even find this lawsuit, Van Zandt Inc., because it's not registered because in this lawsuit that she filed, she didn't request judicial notice, meaning she filed the lawsuit, there was no named defendants, and because of that, she didn't seek from the court that a judge get assigned to the case. So there was no judge ever assigned to this case, ever. There was no clerk assigned to this case, ever. It was a case that sat in court for the sole purpose of a subpoena to Stephanie Jones, in my opinion, okay? But no judge was assigned to the case, so therefore no judge could have signed off on a subpoena. In the state of New York, you don't need a judge to sign off on a subpoena. You only need a clerk. I haven't seen a copy of the subpoena yet, so if and when that becomes public, we'll see if it's signed by anyone. But Samantha does know that there's an ethical way and a non-ethical way to do these types of lawsuits, and I'll tell you why. Because in 2016, she was working with some of her partners at Manat, Phelps, and Phillips, okay? And it was Publishers Clearinghouse versus XYZ Companies 1 through 25 and John and Jane Doe's 1 through 25, known as Publishers Clearinghouse Sweepstakes Fraudsters, okay? So in the 2016, they filed this complaint with the federal government. It was filed in the Southern District of New York and federal court, okay? And when she filed it, the plaintiff was filing it to seek pre-litigation discovery. So what it said was this action is for trademark infringement, unfair competition, false designation of origin, false and misleading descriptions or representations of fact, dilution, computer fraud, abuse, trespass, and other related claims arising out of defendants' unauthorized use to publishers' clearinghouses' names and trademarks in connection with fraudulent advertisements and emails and infection and hijacking of their websites. So I don't know if they got hacked or what, but they said that they, have authorized without authorization, they posed as publishers clearinghouse people for the purpose of deceiving customers into believing they were signing up for a sweepstakes when they hadn't. They may have used malicious computer codes to do this, and the parties in the case were Publishers Clearinghouse, which is a New York limited liability company, and then the true identities of XYZ companies and Jane Doe's are presently unknown, and upon information and belief, information obtained in discovery from third parties such as ad servers and email service providers will lead to identification of defendants. So what they were doing was hoping that they would be able to subpoena these different ad companies that were like selling email addresses and marketing companies that were using these lists to see if they could figure out who was posing as them and fraudulently, getting people to sign up for sweepstakes that weren't theirs. And they had a bunch of different trademarks they claimed that had been infringed. And the wrongful conduct, they said, was that they were using emails and sending people emails that looked like they were coming from Publishers Clearinghouse. So it was like a phishing email, basically. And they were using the trademark of them to impersonate them. And they were trying to figure out who was doing it. It was, that's legitimately a great thing to go against, especially with hackers. And if people are trying to steal people's identities and a company wants to get under the, they don't want to be involved in this and they want to hold them accountable, they tried to do that through discovery. So their goal was they were going to try to figure out who was doing this. And if they could figure out who was doing this, they would amend the complaint and add them for trademark infringement, counterfeiting, a whole host of different claims. Okay. Now, what I want to note here, though, is that this case is incredibly different because they did seek judicial notice. Okay. And they went to a judge and they requested to open up discovery for the limited purpose of subpoenaing specific companies and people to see if they were the culprit. They sent a letter for discovery to the judge a few days after they filed the complaint. The letter to the judge said, "We're requesting permission from your honor to commence limited discovery in advance of Rule 26F conference, and so that we can identify and name as defendants in the action the parties that have damaged Publishers Clearinghouse." They were hoping through this limited discovery, they'd be able to identify them and then amend the complaint. We believe this information will help us identify and then name at least some of the parties involved. Because of the anonymous and convoluted nature of the scheme, we believe pre-26F discovery is the best and most efficient method for ascertaining identities of discovery. So they had to request from the federal judge to get permission to subpoena people they suspected and companies they suspected that might be involved in this. And not only that, they had to send letters and proposed subpoenas and proposed depositions from specific companies that they might want to depose as a part of it. And that was sent a week later. So they sent another letter saying, we would like to have Get Response Inc., Ad Media do and produce documents. We would also like to depose them. And they had to get permission from the judge to do that. Okay. So once they sent that in, the judge gave them an order and they permitted them to do limited discovery. They authored them to serve subpoenas on Get Response and Ad Media, and they said that they could use this to figure out if they could identify these people. Okay. And then he did an order permitting 26F discovery and that they're authorized to serve a subpoena on ad.com under the federal rules of civil procedure and local rules of the courts. So a judge signed off on these subpoenas. So in 2016, Samantha knew that to be above board in this type of case, that you go to a judge, you get permission from the judge to not only start this 26F type of discovery, but also to get permission to issue a subpoena. The amount and the length of time that he allowed was limited, though. Okay. And they had to request an extension of time in December because he only gave them a short window. He said on November 11th, we requested a limited discovery. You granted us this on the 20th of October. We served them on the 24th. We attempted to serve this other place on the 24th, and we served the subpoenas, but we have not yet received any documents from them. And we've received very limited from ad.com and ad media. Meanwhile, the 90-day period to serve process pursuant to federal rules of civil procedure expires on January 5th, and we will request a period of 90 days for an extension. So they needed a little bit more time to get what they needed from the judge. Okay. So again, they knew that to do this kind of discovery, to seek these kinds of documents, to do depositions and to, order production, they needed the judge to sign off on it. And then the judge granted the extension, but then by March 28th of 2017, they said that they respectfully provide notice of dismissal on this action without prejudice. Plaintiff further states that no opposing party has served a responsive pleading or a motion for summary judgment. Plaintiff has not previously dismissed any action of the court. So they dismissed the case. I don't know that they actually found what they needed. And then a couple days later, the case was terminated for the trademark infringement. So they did a voluntary dismissal. So they were not able to identify anyone. So they withdrew the case. So do you see what they did here? They sought judicial notice. They sought the request and the permission of the court to do this kind of discovery because this kind of discovery is not typical. They got permission and orders to issue subpoenas and production of document subpoenas and depositions. The parties either didn't comply or when they got what they needed, it didn't prove they did what they thought they did. And so the case was closed. They took the exact steps you should take if you're trying to figure something out and you're doing it above board. And they named Publishers Clearinghouse. They didn't name one of Publishers Clearinghouse's, shell companies. So when it comes to the comparison of the case they filed in New York County, we know that they didn't get judicial notice. We know that they didn't seek permission from a judge to open limited discovery. They didn't get an order from a judge for a subpoena. They didn't have anyone from the court ever assigned to the case. As far as the court knew, this was like a case that didn't exist. And if you go to the Supreme Court of New York County, you will not find the case because the cases on the Supreme Court docket in New York County, they only show cases that have judicial notice. The only reason this case was found is because Unicourt, which is the website I use, it's a database that you pay a monthly fee for. It allows you to search federal dockets as well as like 30 different states. And that's where I found it. And they also had the documents there. Unicourt can access things that I can't access, which is why I have a subscription to them. So it proves to me that one, Ezra's not lying. This can be used. But two, there are ethical ways that this can be used. And you use it through the court getting permission, not an end around where they don't tell anyone, not even a judge, what they're doing. So that, I think, can further solidify kind of how shady this is. It's not anything I would ever do. And I think it speaks to the fact that if you want to hide yourself and conceal yourself, you can, file a lawsuit against anyone using a shell company and get a hold of documents that you shouldn't be getting a hold of. So that part of it, I think, isn't going to be good for her. Now, last week, I told you that Brian Friedman said that he'll be adding new lawsuits or he might be suing me and such for other claims. And nothing has been filed by Baldoni or by Wayfair or by anyone in any of the cases, but Jed Wallace is going to amend his complaint. And here's why I think it's important that we talk about him amending his complaint, because she had no clue who Jed Wallace was until she got the subpoena and issued it to Stephanie Jones through the SHAM lawsuit. That subpoena was executed by Stephanie. She handed over a trove of documents, which Van Zandt Inc. had nothing to do with Stephanie Jones and had nothing to do with Baldoni. And Baldoni did not cause harm to Van Zandt. So again, it's not going to look good for her. But because that's how she found out who Jed was, I think Jed is going to be adding new claims against her because he sent a letter in and he said he's filing notice that he informs the court and defendant Blake Lively that he's going to amend his complaint within 21 days of Lively's Rule 12 motion to dismiss. So her motion to dismiss was filed on April 4th, and that means by Friday of this week, he's going to file an amended complaint. He can do new claims for abusive process. He could have, claims for invasion of privacy, interference in his whatever. I don't even know what torts they could do, but I think abusive process for one and invasion of privacy for two, because she didn't know who he was until she got his name through the subpoena that wasn't signed off by a judge. We know that much. And that was obtained through this sham lawsuit. So if Jed is going to add these types of claims, maybe down the line, Baldoni does, and maybe Wayfair does. Maybe, I was watching Ask Two Lawyers. They were saying they could ask for a motion to have them the lawyers disqualified. There could be sanctions. Another option is that if they bring notice to the court and to the judge, a judge can, as a sanction, tell them that everything that they obtained through that subpoena cannot be used in court. And therefore, they have to obtain what they got through legal subpoenas. And I don't know if they're going to get the same thing that way, right? Because he's already quashed similar subpoenas. So this is going to get messy for her. And I think it's just, again, more indication that her lawyers knew the right way to do it. They knew the ethical way to do it. And they did the exact opposite for Blake. And I want to be so clear. This attorney, Samantha, doesn't look like she's a bad person by any means. Like, she fights the good fight. She does product recall stuff for baby stuff with Fisher Price and toys for kids. She's all about like consumer safety stuff. And I think what you have to recognize is sometimes lawyers have belligerent clients that want them to do things, and some lawyers will do things that are not always ethical if they're paid enough. And I feel bad for Samantha. I mean, I guess I don't, because she'd made the decision to do this and she knew how to do it right the first time, and she made the choice to not do it right the second time. All of this could have been so different had she just put her name on the lawsuit and gotten judicial notice from a judge and gotten permission to do this, none of which happened. So Deadline is trying to, kiss up to Blake and Ryan, and they've basically finally said yes. This subpoena that they've had for a week or 2 weeks now, they're finally saying, oh yeah, it was Van Zandt, and they're talking to Brian Friedman, and they're saying, well, Brian actually doubted this was real, and it is true. And he gave a statement to them and said, Miss Lively and Mr. Reynolds' company, Van Zandt, had nothing to do with this case, and they knew it. This sham lawsuit was designed to obtain subpoena power without oversight or scrutiny, and in doing so denied my clients the ability to contest the propriety, nature, and scope of the subpoena. It's true. That's all true. The right to notice is a fundamental right under the law. And he said, there is nothing normal about this. Officers of the court have a duty of candor to the court and an obligation not to file fictitious lawsuits that have no basis in fact or law. A party with no connection to these proceedings asserting a breach of contract against another party they claim not to be able to identify does not qualify. This was done in bad faith and constitute a flagrant abuse of process. So it sounds like, they're going to look at abuse of process. This is a bad faith lawsuit. All of this can be used to get that evidence thrown out. And he's right. Van Zandt has nothing to do with this case. Van Zandt cannot do breach of contract as it results with Justin Baldoni because Van Zandt has nothing to do with Justin Baldoni. But of course, her attorneys have said there's nothing untoward here, just conscientious and thorough investigation. The Lively parties acted upon reliable information and employed common tools such as Doe lawsuits and civil subpoenas that are entirely lawful and appropriate for pursuing claims and uncovering identities of unknown perpetrators of unlawful activities. But again, like I told you, they didn't get permission from the court for this. They didn't get judicial notice. They didn't seek permission from the court to open discovery. Again, Hudson and Gottlieb went on to tell Deadline the lawsuit unearthed the Wayfair party's documented plan in their own words in their own text messages to destroy Blake Lively, blah, 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 blah. But they said, we have absolutely nothing to hide. Miss Lively voluntarily disclosed the subpoena in her first filing, which is weird because she didn't actually disclose it. Knowing that it would ultimately be produced to the Wayfair parties in discovery, that is precisely what will happen as her claims move forward in the proper litigation process. Weird though, right? Discovery is supposedly, supposed to be closed here soon. And Blake has not provided a copy of this subpoena to Wayfair. Nothing's been disclosed to Wayfair at this point, and it sounds like Brian's going to go for the jugular with abusive process claims, possible disqualification because it's a bad faith. See if there can be sanctions from the court. There's a litany of different new claims he could file, and he could also get sanctions for the lawyers, and they can be reported to the bar. And no matter what they say about it being normal, it's not. And he's right. So, what are your thoughts about this? What do you think a judge in this case, if, Judge Lehman is assuredly going to find out about this at some point. What do you think Friedman is going to do? Is he going to amend? Is he going to seek, dismissal or disqualification of these attorneys? Do you think there could be sanctions of the evidence? Tell me in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and please click the bell so you never miss a video. Thanks so much for watching. Bye, guys.